My name is Carrie Farmer, and I'm the co-director of the Rand Epstein Family Veterans Policy Research Institute. I want to welcome everyone to this webinar today. This is part of our bi-monthly webinar series focused on high-priority veterans policy issues. Okay, we'll go to the next slide. Veterans Policy Institute has its mission to conduct interdisciplinary research to improve the lives of those who have served in the U.S. military. We aim to publish and widely disseminate all of our research findings. So this webinar is part of that effort, so that we can connect objective and rigorous analysis to decision makers, so that we can improve evidence-based decision making. I'm going to note a couple of quick housekeeping items before we get started. We have the chat feature open. I think some of you have already started using that, so please feel free to ask questions or share resources that the audience might be interested in. To ask questions to the panelists, please use the Q&A feature. We will monitor that and we'll try to get to as many questions as we can. All right, next slide. Today, I'm pleased to introduce my colleague, Angela Clegg, who will provide a brief presentation of our new report on veterans who leave the military under other than honorable conditions. Angela's presentation will be followed by a panel discussion with our guest experts, Secretary Tony Woods, Michael Wishney, Jim Craig, and Heather Salazar. The panel will be moderated by Rajiv Ramchand, who co-directs the Veterans Institute with me and is a co-author of the report. Angela is an associate social scientist at RAND. Her research interests include workforce talent management and family quality of life, and she has methodological expertise in demography, survey design and analysis, and qualitative research. She has a PhD and a master's degree in sociology from UCLA. And with that, I'll turn it to Angela.
Thank you, Carrie. I'm excited to be here and present our work. The next slide. So our perspective does three things. First, we explain how other than honorable, or OTH, discharges affects VA eligibility. Second, we explain common public health issues for OTH veterans. And third, we recommend ways to support this vulnerable group of veterans. Next slide. The official term for discharge status is called characterization of service at discharge. This is based on a service member's performance and behavior during their military service. For simplicity, though, I use the term discharge status. There are 6 possible discharge statuses shown on the slide from left to right: honorable, general, other than honorable, bad conduct, and dishonorable or dismissal. The first 3 are administrative. Administrative discharges are separations from military service that do not involve judicial proceedings. In contrast, bad conduct, dishonorable, and dismissal are punitive, meaning these discharges were given as punishment after judicial proceedings. Dishonorable and dismissal are for the most severe misconduct. Dishonorable is for enlisted service members, and dismissal is for officers. We focused on OTH veterans because they constitute the largest share of discharges that restrict VA benefits. Next slide. Commanders often issue OTH discharges to address behavioral problems without judicial proceedings. While this may include offenses that have impeded the mission, commanders have also issued OTH based on minor problems, like occasional tardiness, a disagreement with a superior, and isolated substance use. Next slide. Veterans who served in Operation Enduring Freedom, Operation Iraqi Freedom, and Operation New Dawn were issued more OTH discharges than any other veterans in U.S. history. This means that our most recent cohort of veterans who saw combat are also least likely to have access to VA benefits. Next slide. OTH discharges have also disproportionately affected 2 vulnerable groups. First, Over 13,000 service members with PTSD, traumatic brain injury, or substance misuse separated with OTH. And second, LGBTQ plus veterans. Over 100,000 LGBTQ plus veterans have gotten an OTH discharge, and over 14,000 LGBTQ plus veterans got an OTH discharge during Don't Ask, Don't Tell. Next slide. Despite not being punitive, veterans with an OTH discharge status have to undergo a character of discharge review to determine their eligibility for VA benefits, just like veterans issued punitive discharges. Next slide. Veterans get their discharge status from DoD. If their discharge status was less than honorable, they can get a character of discharge review at VA. During this review, a VA adjudicator evaluates whether less than honorable veterans are eligible to receive VA benefits. There are three possible determinations: honorable or eligible for all VA benefits, eligible or may get VA health care, and dishonorable or ineligible for VA benefits. Next slide. During the review, VA adjudicators evaluate whether a veteran's discharge status was from a bar to VA benefits. There are two types of bars. One is called a statutory bar. For example, someone who is AWOL for more than 180 days. If a veteran's discharge was issued based on a statutory bar, the VA adjudicator will reject the petition. The other is called a regulatory bar. For example, persistent misconduct for at least 2 years. In this case, the VA adjudicator will consider their case for benefits. New regulations also require VA adjudicators to consider compelling circumstances, like mental and cognitive impairment, physical health, combat-related struggles, and military sexual trauma. Military sexual trauma refers to sexual assault, sexual harassment, or gender discrimination during service. Next slide. OTH veterans can also petition to upgrade their discharge status through DoD. These cases are reviewed by a board for correction of military or naval records, or a discharge review board. The Hagel Memorandum directs the boards to give liberal consideration to PTSD symptoms when making decisions. However, the process tends to be slow and few veterans succeed. For example, only 5% of mental health and 17% of sexual assault cases got upgraded in the Air Force between January and March of 2024. Next slide. More OTH veterans have health issues than honorable veterans, like generalized anxiety, depression, PTSD, traumatic brain injury, alcohol misuse, substance misuse, homelessness, and suicide. This emphasizes how important it is to make sure that OTH discharges are only given under the right circumstances. Next slide. We have several recommendations for DoD and VA, beginning with DoD. Some commanders may show bias in discharge status decisions. So DoD could provide a structured checklist for what behaviors should lead to what discharge status. We also encourage having a panel, counselor, reviewer, or independent medical evaluation board review each service member's paperwork to make sure an OTH discharge makes sense. Second, we recommend ensuring these veterans get counseling about their benefits. This is supposed to be done, but there needs to be increased oversight to ensure that it is actually done. Because petitioning VA for benefits can be a long process, we also suggest providing referrals to local civilian services. Finally, we recommend DoD and VA share data to find where OTH veterans are slipping through the cracks. Better data would also help to answer questions like, is the percentage of OTH veterans changing over time? Is the percentage of OTH veterans that can access VA services increasing? Next slide. VA can also strengthen existing support for OTH veterans. Sometimes OTH veterans who qualify for VA benefits have to wait a long time to access their benefits. VA can speed up the process by making sure the Veterans Benefits Administration shares their eligibility decisions with the VA healthcare system. We also recommend strengthening VA training, resources, and personnel. One way to do this is by issuing a directive with a chart to help clarify how discharge status relates to VA eligibility. Another strategy is providing VA adjudicators with decision tools with information on PTSD, traumatic brain injury, and military sexual trauma. Including a psychologist, psychiatrist, or neurologist in the adjudication process may also support decision-making. Finally, we recommend that veteran service organizations, or VSOs, encourage participation from OTH veterans. OTH veterans may avoid VSOs because they are concerned about stigma surrounding their discharge status. One way to encourage participation is by including OTH veterans in the VSO's mission, target population, or eligibility criteria. We also think VSOs can support OTH veterans by training their staff members on discharge status and characteristics of OTH veterans to understand and reduce stigma against this population. So this concludes my presentation. Thank you so much for listening. I'll now turn it over to Rajiv Ramchand for our panel discussion.
Thanks so much, Angela. This has been great. And anyone, please, we're going to monitor the questions in the chat. So please go ahead and ask the questions. Let me introduce to you the panelists really briefly. You can see their full bios on the event website. Jim Craig is at the University of St. Louis. He's the chair of the sociology department, professor of and president of the Veteran Studies Association. He also, I think it's noteworthy, established the Student Vet Center at the University of Missouri St. Louis, as well as founded the school's Veteran Studies program. Michael Wishney is the William O. Douglas Clinical Professor of Law and counselor to the Dean at Yale Law School, where he also directs the Veteran Legal Services Clinic there. So thanks so much for joining us. And we're really honored to have Secretary Tony Woods. He's the Secretary of the Maryland Department of Veteran Affairs and Military Families. He's an Army veteran with 2 deployments for which he received Bronze Star and still serves as an Army reservist. And also joining from RAND is my colleague, Heather Salazar, who is Legislative and Government Affairs Analyst at RAND for Veterans. So thank you so much, everyone, for joining us. And Angela, thank you again for joining us. Secretary Woods, I'm just going to go straight to you. We heard a lot about the process and helped, I hope, clarify some of the issues that people have and confusion about, you know, what an OTH is. I wonder if you could put the personal narrative behind it, because you've spoken openly about your own experience. So tell us your story. What happened? What was the process like for you? And how did it affect you as a person, as a veteran, as a service member?
Yeah, well, I'll try to keep it brief, but like so many people who join the military, I had a family connection to serving in the military. My grandfather served, father served, mother served as well in the Air Force. But my mom raised me working as a housekeeper, as a single mom. And so military service was going to be my pathway to the middle class. So I was fortunate to get an opportunity to go to West Point and then join the military. As you mentioned, did 2 deployments to Iraq. But it was also, you know, during that time that, I, as a person who was serving under Don't Ask, Don't Tell, serving in the closet very much at that time, I was going to be given an opportunity to go back and teach at West Point. And so I was getting a grad school degree, and I realized as I was going to be teaching cadets who lived under an honor code to not lie, cheat, or steal, or tolerate those who do, I would be essentially having to lie to them. As folks who've been in the military know, it really is a part of your whole life, for good reason in many cases, but it also means you don't have a lot of privacy when it comes to who you're dating, who you're married to, all those types of things. And so for me, the idea of living a lie, when I knew that serving in silence didn't actually improve good order and discipline, it didn't improve unit cohesion, if anything, it had the opposite effect. I made the stand that I, didn't want to continue to serve in our military if I was going to have to lie about who I was. So I violated the don't tell portion of the Don't Ask, Don't Tell policy at the time. And it resulted in an investigation being kicked off. And then I received an honorable discharge, which in hindsight and seeing the presentation, realizing I was really lucky, very fortunate for that to be the case, because I was then also able to, in the future, use my benefits to help to continue to enrich my life. I'll close this out by saying that I was fortunate to have the opportunity to advocate for the repeal of Don't Ask, Don't Tell, along with many others, working with the Service Members Legal Defense Network, which did great work on this. And then, as you mentioned in my introduction, got the opportunity to start serving once the policy was repealed. So since 2014, I now serve in the Army Reserve. I still do so today. And it really is a privilege to serve. And I'll close out by saying all of our beliefs and faith in the military and in the professionals who serve in the military and their ability to serve with openly gay and trans service members and full range of the LGBTQ community, they proved that we can have a military that can maintain good order and discipline, function perfectly well, and not compromise the mission, even though we have this wonderful diverse population serving the military today.
Thank you, Secretary Woods. And I really want to hear how that experience has affected your current, but we'll get to that in a bit.
Of course.
How it's affected your work as secretary. Jim, I want to turn to you next. We're going to stay kind of at the DoD side and work our way through. And we're co-authors on the report. And you're a veteran. And when we were talking about this, you would always say to us that OTH is a quick and easy way for commanders to get rid of problematic service members in their units. They were having a problem. It was quick. It was easy. It was to the point. They didn't have to go through a court martial. Can you just say a little bit more about that?
Yeah, thanks. And I will. I just want to openly acknowledge that what I saw, what I participated in as a mid-level officer, it I think is instructive and was helpful for the writing of the report. But I can't tell you it's universal. It's what was happening in my unit and my experience. And at the time, we were trying to deploy. And when pressure is on in units to deploy, commanders see a deployment on the horizon. They start to get nervous about filling their ranks with soldiers and with the best soldiers. And when you have soldiers who are struggling to adapt or who are having experiences that are making them not as effective as they should be in another time, you might have more cushion to retrain them, to transfer them, to do some work with them. But in a time when you're trying to fill your ranks, it's difficult and you don't have that flexibility, or you feel like you don't have that flexibility. So small infractions can become large enough to instigate small judicial processes. So one way to do that is to take these small sets of infractions, like a series of small ones or a medium infraction, and initiate judicial processes, not non-judicial, not Article 15 process, but instead a summary court or some sort of small legal process. And then that procedure really is designed to, rather than to punish or to rehabilitate, it's designed to ramp up pressure on the soldier to say, why don't you take what is equivalent in the civilian world to a plea bargain? It's a Chapter 10. And a Chapter 10 is essentially says, you don't want to be here. I don't want you to be here. Let's do this discharge and we can be done with this very quickly. I've seen soldiers leave in under 3 weeks under the Chapter 10 procedures. And the problem is the commander doesn't understand other than honorable discharges. The commander has never been discharged. And the soldier clearly doesn't understand other than honorable discharges. And it sounds pretty good in the immediate time frame. But what we've learned is that characterization of discharge is problematic, not only for the soldier, but actually for the unit too, and for the military. And so I've seen this happen. To be fair, I've used this procedure and only after I became interested in doing this work, after I became a veteran, did I really fully comprehend what I had done and or what I had participated in. So I guess that's kind of my experience there. And I do want to remind you, there are soldiers who want out, and this might be a good thing, right? And there are places for this discharge, but other than honorable is not dishonorable, and dishonorable is the status in our title, in our laws, about what constitutes a veteran or not. And that's why I think this paper was important. The numbers speak for themselves, 6.5% versus 1s and 2s over the course. This was used widely, and it has detrimental effects.
All right, thanks, Jim. Mike, turning it over to you, does what Jim said, does that, I don't know how many hundreds of cases of discharge upgrade cases you and your students have been involved in, but does it ring true to you, what he's saying? And can you talk to us a little bit? I mean, we referred to kind of the legal, kind of statutory, but can you talk to us a little bit about what you do, the types of veterans you serve, what they come in with knowing, and what that appeal process, if you will, if that's the right word for it, what it looks like?
Sure. First of all, thank you so much to Rand for undertaking this study and bringing some really important and overdue attention to what's a very substantial population of former service members in our country. In the clinic, we have represented through some class actions tens of thousands of veterans with other than honorable or general under honorable conditions discharges as well, primarily other than honorable. And I guess what I want to talk about a little bit is the process and really what is to be done about this. I think our experience suggests to us that, of course, there is a need in many circumstances to move someone out of a unit who is struggling to perform their job, so the unit as a whole can function. Of course, that's an important need. And Congress over the years has recognized that there has to be flexibility in the part of command to do things like ensure a unit is fully functioning. So Congress has not sought to regulate or over-bureaucratize those decisions, but it has trusted that DoD will exercise this power judiciously, because an other than honorable discharge status is really like a scarlet letter. It's a lifetime stigma. Often for someone who might be 18, 19, 20 years old, it's practically their first job ever and the only job on their resume. And their discharge status will haunt them for the rest of their life in various formal legal ways, like eligibility for VA benefits, but in countless informal, socially powerful and destructive ways. And there was an allusion to that at the beginning when Angela mentioned that some VSOs won't let you join. You can't be a member of some VSOs if you have an other than honorable. But many of our clients have come home to their families destroyed by the experience of trying to live up to a military tradition, like you described, Secretary Woods, and their family, struggling and being kicked out. And maybe because there was underlying misconduct, but just feeling like they have completely let down everyone around them and just ashamed for the rest of their lives and their communities. That's an enormous weight to carry. So what did Congress do? It trusted that DoD would not overutilize this. And so to see the spike from 1 or 2% to 6.5% suggests that DoD is largely responsible for this problem. There's no evidence that soldiers and sailors and Marines in this, and airmen in this era, were more inclined to engage in misconduct than those in other eras. But the command in the last period of time has been more punitive. And as Jim says, probably not in many cases recognizing the lifetime consequences of these decisions, often made by someone who might be 25. I mean, it's not like they necessarily have had a lot of experience themselves, nor Does command often have full or perfect information about someone's medical or behavioral history or other factors that may have contributed to the misconduct? But here's what Congress did as a back end. They set up two systems. One are the discharge review boards and boards for correction of military records that Angela mentioned. Those date to World War II. And those are supposed to upgrade the status of people who petition and can show that there was a mistake or an unfairness in their discharge status. Those boards, unfortunately, over the years, largely failed to live up to what Congress charged them to do. And for many, many years, they rejected 90 or 95% of the veterans who came to them seeking a discharge upgrade. That's improved recently, and the number's even a little bit better, I think, in the most recent period. So they are starting to function a little bit better, but they remain very laborious, paper-intensive processes that are difficult for many veterans to access. There are very few lawyers who will represent veterans in that process. Many VSOs don't do the discharge upgrade work either. And the result is that many veterans can't access this system that was meant to be a kind of safety net, a backstop. So a decision is made in haste with imperfect information in the field, but then these boards with time are supposed to be able to reflect and correct errors or injustices, but they really ceased to do that. The other system, and the last thing I'll say, that Congress intended as a backstop was the VA. The VA has the statutory authority, and has for a very long time, as was explained, to make it, in fact, the obligation to make its own independent determination as to whether a service member's military service was honorable for VA purposes. But for many, such that even if they had an other than honorable, they could receive VA benefits. VA was supposed to make up its own mind. But for many, many years, VA refused to do that. It just rubber stamped what the military did and failed to do what Congress charged VA to do, which was to determine on its own whether other circumstances, such as undiagnosed PTSD or an undiagnosed TBI or experience of military sexual trauma, or the kind of race discrimination that pervades the military justice system as much as it does the civilian justice system. The military is not immune from the same kind of unconscious bias that is present in all of our judicial system. But the VA stopped doing its own meaningful review, and it's improved very recently. However, that process also remains extremely cumbersome and paper intensive, and now it's backlogged as well. And when given an opportunity very recently to make its own standards more generous and flexible by repealing the 3 regulatory bars, for instance, which VA chose itself to impose beyond what Congress imposed as limitations, VA refused. In the face of advocacy by many organizations, VA swung and missed, and said, no, we're going to retain these additional barriers that are just purely regulatory, purely within the agency, not mandated by Congress. We're going to retain those, create another little special exception if you can put enough paper together, but maintain the cumbersome process that frustrates Congress's intent that between the military review boards and the VA, there be these 2 backstops, recognizing the somewhat rough justice that sometimes happens in the field when discharges are made.
Thank you, Mike, for that. That's really helpful. Angela presented these systems as as they exist, as you said, that the DoD and the VA system. But it's helpful to hear, kind of, at least partially through lived experience, the process of going through them is not as easy as an image on a slide might make it look. You spoke about, and I think that was what you meant, what the VA has done, which is their recent final rule, update and clarify regulatory bars to benefits based on character of discharge. Heather, I wonder if you could explain a little bit about what that recent ruling was, and what it did, how it differs now than it did in the past, and maybe if what prompted VA to kind of create that.
Thanks, Rajiv, for that question. It's been an ongoing battle to the point of legal battles in the courtroom, pushing VA to address the expansion of benefits for this group of veterans. It was a few years ago where there was a lawsuit that was filed, and VA, slowly started the process. And so they implemented or proposed rule. Lot of comments, hundreds of comments. And so at that point, they took the comments and, had listening sessions to try to figure out what they wanted to do. And this past April, they published what the final rule was, which when you do a comparison to what the proposed rule was a few years ago is quite different than what it is today. Today, they only eliminated one of the regulatory bars, which was the one regarding homosexual acts. So that is not in the Code of Federal Regulations anymore. But there was also a push to clearly define and address more of the willful misconduct, because what is that? A lot of the adjudicators, how do you define willful misconduct? And what is an offense of moral turpitude? I mean, what is that? How do we define that? What is that supposed to be if you are being limited in your disability benefits or your housing benefits? What is this offense? And there was very little clarification. And so they tried to explain this more in terms of putting specific circumstances. So they have to take into account mental health conditions or your combat experience or your physical health or assault or things like that. But still, there's no clear and definitive measure of what those regulatory bars are. So those two still remain. And there has been a loud pushback from VSOs and advocates to say, well, what happened to the proposed rule from a few years ago, that you were listening to us in terms of what we wanted to say, how we wanted to see it. And again, the regulatory bars are exactly that. The regulation. VA has the authority to get rid of them, to amend them, but that has not been done, minus the one regulatory bar that has been lifted. It's different when it comes to the statutory bars, as that has to be something that's been changed by Congress. But with these other ones, advocates are still pushing for these to be addressed systematically and also clearly. One of the submissions with this final rule was from the Department of Defense, and they said, we need some of these still in place because we use it as a means for punishment or means for maintaining discipline and readiness. But as we heard Jim and Mike and Tony say, you don't, when you're 18, 19 years old, you don't think about what is going to happen 10 years down the road if you have a separation that could affect your benefits. So there's a lot that needs to be done in order to understand, not just from the public's view, but also within VA. How do these adjudicators really understand what they are signing off on? And are those individuals who may have had mental issues or physical issues that led to whatever behavior caused them to separate, that they are the ones that need those benefits sometimes the most? So it's going to be interesting to see how this continues to play out, both in the public eye, in the courtroom, in the advocates, in the advocates realm.
Great. Thanks, Heather. Before Secretary Woods getting to you and what the state of Maryland and other states might be doing, which is a question, I want to touch on, and this is open to anyone who wants to answer it really, because I'm hearing kind of two things. We've heard that a lot of veteran groups and VSOs are advocating for changes and more allowance or more benefits for OTH discharges. But then we've also heard people say that some VCOs it's stigmatized still within some VCOs. So VSOs, sorry, not VCOs. So I wonder if any of you, and then another question that came up in the chat was that, there may be even even outside of the VSOs, there might be other employment or in loans or bank loans that might be ineligible for those with other. Can anyone speak to that? Does anyone have knowledge of kind of how do we balance VSOs that are working to change this and those that are stigmatizing those with it? Are those the same organizations? And then secondly, you know, how does this OTH kind of discharge permeate out into the business industry? And I'll just leave it there. Mike.
I can speak more to the second question, Reggie.
Yeah.
I would say just in general, I think on the first one, the VSOs are becoming more sensitive to the lived experience of service members with bad paper. And I think that is naturally leading more slowly in some organizations than others to an understanding of why someone might end up with bad paper other than that they were a screw up. And for many people, there are underlying reasons. But I can't speak to specific VSOs sort of internal processes. On the latter, it's notable to me that in the 1970s, in the mid-70s, the Department of Defense did a major study on discharges, its own discharges, and big published report, and found that Black service members were nearly twice as likely as white service members to be discharged with bad paper. Also, Latino service members elevated rates. Based on that, in the late 70s, so a few years after DoD's own analysis, the EEOC, the Federal Equal Employment Opportunity Commission, held that because discharge status was so permeated with race, that for employers to rely on discharge status as a reason to hire or fail to hire somebody could violate Title VII, the federal statute prohibiting discrimination based on race in employment. That is, discharge status itself was so tainted by race discrimination that it was unlawful under Title VII for employers to rely on it, to prefer, say, someone with an honorable over someone with an other than honorable. And several court decisions adopted that view of the EEOC. So there's several decisions from the late 70s and 80s in which courts affirm that for an employer to rely on discharge status is potentially to violate Title VII by engaging in unlawful race discrimination. Skip ahead many more years. A few years ago, my students and I, representing the local chapter of IAVA, an important VSO, Iraq and Afghanistan Veterans of America, went to our state equal employment agency, like our state EOC, and asked them to issue renewed guidance on this, which they did, advising employers that because today, recent studies have confirmed that unfortunately race continues to infect discharge status, as does disability discrimination, because there's so much undiagnosed PTSD and TBI underlying so much of the misconduct that leads to bad discharges, as well as sex discrimination. So many people who experience military sexual trauma or who served before the repeal of Don't Ask, Don't Tell, experienced sex discrimination, that the Connecticut agency on its website today says that employers who rely on discharge status may violate a host of federal and state anti-discrimination laws if they treat discharge status as a relevant employment criteria. And so that led all these employer associations in the state to kind of train up their members, say, hey, this is just not a permissible basis. Unfortunately, the system is so rotten that it may be unlawful for employers to credit it at all.
Wow. That's really fascinating.
Can I have a quick follow-up?
Yeah, go ahead.
So I would just say, and I work mostly with student veterans, which aren't all young veterans, but there is a unspoken social penalty to an other than honorable or not something that's not an honorable discharge, even on college campuses, among students and veterans who are moving forward with their lives, attempting to transform themselves into something else or better. And we find that on our campuses where someone with a general or an other than honorable, even if they are eligible for benefits, will shy away from the services provided, from the spaces provided for veterans on our campuses. And we have to be very open and available and broadcast that we are open to all. And if you don't do that, there's an assumption that you are not. And so that's a really important, like unwritten, but a social stigma.
That's really interesting. Thanks. Secretary Woods, how does discharge status affect veterans in Maryland access to state level benefits? And then that's the first part of the question. The second is, to the extent that how variable is that across the other states that you might come into contact with or work with?
Yeah, I wanted to just sort of quickly say, Mike and Heather's comments really resonated with me, and I wanted to allow sort of others to chime in before I did. You're absolutely right. Discharge status plays a really significant role in the post-service life of a veteran. We see it play out in ways, yes, for access to benefits, which is kind of the most obvious, but there is absolute stigma associated with it. We already have a population that is somewhat reluctant to take advantage of the benefits that they've earned anyway, right? About 40% of veterans take advantage of their benefits. That falls off, or it's a smaller number for women veterans who might not see themselves as quote unquote veterans. And so if you ask them, have you ever served? They'll say yes. But if you ask, are you a veteran? The answer is different. I've seen this sort of other than honorable versus honorable play out in organizations that, of course, do want to hire and want to offer preferential hiring for veterans, and it comes into play in that exact way. So it's absolutely right. And I think I would just sort of echo what Mike said in terms of when you're asking a young service member who doesn't even know about the benefits that they might have available to them in the future to make a very important long-term decision. They're doing so at a disadvantage, right? They already don't realize the VA home loan benefits, the education benefits, the GI benefits, the healthcare, all the different things they would have access to, let alone the sort of subtle stigmas they might encounter within an organization or with the future employer. I'll quickly add that with my experience of being discharged from the military, I was fortunate, like I said, to get an honorable discharge. But on my DD-214, it said homosexual admission. So every single time I wanted to go to an employer and take advantage of their desire to hire a veteran, I also had to make the decision, well, am I ready to come out to this employer or come out to this recruiter or come out to this whoever it might be, which again, at that point, I was quite out and quite proud about who I was, but I didn't always love knowing that the conversation was forced by this official government document that I had. But Rajiv, to get to your question, which is an excellent one. So here in Maryland, one of the things that I've been really excited to implement, and it was just sort of a privilege to find myself in a position to have been discharged from the military because of Don't Ask, Don't Tell, and then find myself in a position to actually help service members who experienced the same thing. It was really kind of an honor and something that I was really privileged to do. So one of the things that the Maryland General Assembly passed in 2022 is what they call the Restoration of Honor Act. And what this does is it restores state veteran benefits to veterans who have an other than honorable discharge, a general under honorable conditions, or an uncharacterized character of service due to sexual orientation, gender identity, or gender expression. And unfortunately, it was sort of almost an embarrassment in the transition between the previous governor and now Governor Moore, who is also a veteran. My department was charged with updating our regulations to implement that legislation. It was almost missed. So shame on me if we would have missed the opportunity to do that. But we went forward and created the regulations, which allows us to take advantage of the same language we've heard, liberal consideration, when it comes to restoring state level benefits. The thing that we did is we went further, and which is why I really appreciate Mike's work and Jim's work, but we entered into a partnership with the University of Baltimore Law School's Veteran Law Clinic, because we knew that veterans who may have experienced this, if they're even willing to come forward, if they're willing to trust the government again, which many of them had a pretty terrible experience with how they were discharged from the military. So now we are asking them to take a leap of faith and come back into the fold and say, maybe trust us to get this right this time. And so we were proud to partner with that law school because they will also work with service members on getting their federal discharge status upgraded, which, as we mentioned, really unlocks the key set of benefits. You're seeing this take place across other states. There's an effort in this regard. But I do think Maryland is an early leader in this way. Unfortunately, it does tend to kind of break down in red state versus blue state dynamic, which is kind of rarity when it comes to veteran and military issues. You tend not to see a lot of politics, but when it comes to going further for this particular population, you unfortunately still see it playing out in that kind of political dynamic. But it has been an honor to kind of push forward with implementation here, and also to start to tell more inclusive stories of those who serve. And so one of the things that it was a privilege for me to do in my role was to also advocate that the U.S. Department of Veterans Affairs now start to provide gender-affirming surgeries for trans veterans, which is an area we're waiting for that implementation to come forward, but we haven't seen them move forward yet.
I'm kind of mixing in questions from the chat and the Q&A as we go, but I did want to say that in the chat, some people are, Mike posted some information about what Connecticut has done with their benefits. Somebody's posted about New York as well, and they've posted more information about the restoration of benefits for LGBTQ plus veteran and military families. So thank you for posting those in the chat. It's good for people to have access. And I also just want to highlight that somebody whose son has an OTH discharge just kind of echoed what has been stated by some of you, that it is very much a tremendous burden. I'm a veteran who's living with this issue with my son who has an OTH discharge. So what you're saying resonates, and we're hearing more about it. Angela, I'm going to ask you, I think this might be a pretty tough question, and maybe you don't have the data, but it's from the chat, and it says, is there any evidence to suggest differences between discharge status and OTH discharges among those who served in the active component versus the reserve component?
I don't think that data is publicly available. There is some data on branch level differences, but that still is taken from like the 1980s. So it kind of speaks to one of the recommendations of tracking more of this information, making this data publicly available so that we can see these trends over time and see how discharge characterization varies by active and reserve, as well as other service characteristics.
Great, thank you. Another question, this has come up a few times in the chat and in the Q&A, which is, can you speak to uncharacterized discharges and how this limits options to different benefits? Anyone? That's open to anyone. Sorry.
I mean, I was going to invite Angela in on the numbers. My understanding is that the number of people with uncharacterized discharge is relatively small in this population, and it commonly results from people who struggle in basic training. It's often used for someone who in the first 180 days has difficulties and is separated, and that it is not quite as stigmatizing as something that says other than honorable, and that it tends to have a more neutral character of service description. I really appreciate Secretary Woods raising the point that it's not only the discharge status, but it can be the narrative reason for discharge that is the difficult aspect of a DD 214. We've represented many veterans who have an honorable discharge that says personality disorder, and then they try to go get a job, and people engaging in disability discrimination are afraid to hire someone whose one job says that they have a severe and lifetime mental health condition. But on the uncharacterized, my understanding is that it's a little bit more neutral. It's in terms of its social stigma than other than honorable, for instance, and the narrative reason is generally less stigmatizing. People are ineligible, but again, I think that that's a much smaller population here. And it's people who, by definition, have not been in service very long. Angela, am I right about the numbers? I'm cold calling you. I'm sorry for that.
Yes, you're on track.
And I would add to Mike's point, I think that that's been very consistent with how I've seen it as well. It's actually it's rare to see, but I will add that it also potentially adds to our undercounting of the impact of our discriminatory policies for this community, because I'm aware of 2 people in my own personal network who have uncharacterized discharge statuses who, during their kind of initial entry training or AIT, that sort of secondary training, were removed because of their sexual orientation. But it doesn't sort of show up in the same statistics in a way because it sort of is allowed to kind of fall under the radar with this type of characterization.
Somebody in the chat asked if we have a list of states that have passed restoration of honor type acts. And I don't know, we'll look into that. And if there's not, that might be a good thing for Rand to do. Again, lots of comments in the chat affirming what's been said, and also highlighting that, you know, somebody spoke to an employment challenge that, you know, somebody with OTH had. They said, you know, they didn't care that the person was gay, they just cared about that they had an OTH. So it seems that there are some places where there is some discrimination, or people are using it as a barrier. Any branch level differences? Sorry.
I was just going to see, Rajiv, if I could add to this, to the point of, you know, so we did look at other states, and there's a small number, of course, who have a similar Restoration of Honor Act like law. There are a large number of state level benefits that I would also point out. We in Maryland operate the Maryland Veteran Trust Fund, which is an emergency financial relief program where we literally prevent people from going into eviction or foreclosure or having their car repossessed, you know. Housing programs, small business programs that are specifically designated for veterans of that state at the state level. These all fall below the federal level benefits, which we often know about and are really robust. But there are a very significant number of benefits that you see at the state level. One of the things that really stood out from Angela's presentation for me, and where you're going to see us try to make a push here in Maryland, is so we've now included sexual orientation, gender identity, and gender expression. But we also know that PTSD, TBI, substance misuse, those military sexual trauma, these all also play a factor. And so what we're hoping to do is amend our Restoration of Honor Act to actually include all of those, if we can allow us to take that liberal consideration of if that is also involved in what resulted in the discharge status.
If I can just hop in here, the conversation has kind of gone in a state and local direction a little bit, which is appropriate, especially given it seems like many of the backgrounds of folks in the chat and people wanting to take advantage of sharing time with Secretary Woods. An additional area that I think state and local actors can, I don't want to let the VA and DoD off the hook, but we're talking state and local, you know, efforts here. Is that, as sort of signaled by the report, there's certainly evidence that veterans with bad paperwork other than honorable discharges are overrepresented in the justice-involved veteran population, those who are incarcerated or facing criminal charges. And in Connecticut, we've begun to work with incarcerated veterans, many of whom are eligible for VA benefits, but don't know it. But if they can get connected to benefits before they return to civilian life, their reentry is going to be so much better than if they have to start from scratch when they get out. Those who enter the prisons with benefits have the right to apportion them, that is, transfer them to their families, as the benefits that can be received by someone while they're incarcerated 60 days after they're convicted of a felony drops down to 10% or less, but the balance can be forwarded to their dependents. Very few people know about this, and so families are often deprived of the benefits that their incarcerated loved one has a right to provide to them. States can play a major role here in ensuring that families of incarcerated veterans continue to receive into the household the veterans' benefits, and that incarcerated veterans, including those who need a discharge upgrade or a character of discharge status determination by VA, get that done before they leave. In fact, we're exploring now whether VA telehealth can begin while people are incarcerated, which can potentially bring 100% federally funded healthcare into state and local prisons. Let me say that again, Secretary Woods, 100% federally funded healthcare into prisons, which typically have god-awful, atrocious healthcare programs, and even provide continuity of care. So an incarcerated veteran could potentially begin doing talk therapy on the phone with a therapist, and then see that therapist in the week that they're out, which will likely result in much better outcomes for this same population, veterans with other than honorables, many of whom are swept up into the criminal justice system. So a lot of space for innovative state and local programs there, I think.
Mike, you'll be getting a follow-up from me. Thank you.
Great.
Rajiv,
These
can I
webinars
just...
go ahead.
Can I just, there was a couple comments asking about VA discharge upgrades and GI Bill benefits. I just want to make two clarifications that the Veterans Administration does not upgrade the discharge status. It's just the characterization. So if you wanted to go from other than honorable to honorable, that process has to take place at the DoD level. Whereas this characterization, and it gets confusing because VA uses some of the same terms as DoD on your discharge. VA is just looking at the quantity of your service to determine if for whatever reason you receive the other than honorable, like Jim was saying earlier, because it was just a quick, easy, they wanted to get out, but they had served honorably. VA will make that determination that they're honorable for the purpose of veterans benefits, or dishonorable if there's a statutory bar, or they just determine the conduct not appropriate. So the terminology itself is also confusing, but I just wanted to make it clear that it's the Department of Defense that does the official discharge upgrade, not the Veterans Affairs. And so regarding GI Bill benefits, if you do receive a Department of Defense discharge upgrade to honorable, you can apply for GI Bill benefits. The clock will restart for those benefits to apply for. If you are honorable under VA benefits, for VA benefits, that does not change your discharge status, so you would not be eligible. But if you're DDU 14 in the Department of Defense,
okay, great. Jim, you went off mute real quickly. We only have 1 minute, so I just want to make sure.
Oh, I just wanted to say that this is really important. What Heather's saying is important, and the language really matters here. The characterizations of service discharge, which are like honorable, general, other than honorable, and then the punitive discharges. If you have one of those two that you need to go to the VA and ask for your benefits, they will turn around and tell you that your other than honorable is honorable for, they use that same term. And their three categories are honorable, eligible, and then they use the term dishonorable, which is not a term in the DoD lexicon. So it's really an interesting struggle.
It's very confusing.
Yeah.
Well, hopefully we've made it clear in the report, all of these technical issues. I know that we're right on time. I just want to thank the panelists for just such an incredible discussion and really informative and thoughtful. So thank you everyone for joining, and thank you everyone on the chat and in the Q&A for being so engaged in this discussion. Obviously, this is a really hot topic. There's more to do on it, and we really just appreciate everyone's joining us. Veterans.rand.org is where you can sign up for our newsletter and more information about our webinars and our research. So thanks everyone, appreciate it.